So recently, several states have adopted legislation similar to various offshore jurisdictions, which provide by statute various degrees of asset protection for a settler's interest as a beneficiary in a self-settled trust. Now, some of you have asked me, and we're going to talk in more detail about this tomorrow morning, but how you combine the trust structure of an asset protection trust with the usage of LLCs. And the way you do that, and I'm not going to spend a lot of time right now, but the way you do that is you actually have the asset protection trust own the member interest in the LLCs. Instead of the client owning the member interest, the asset protection trust owns the member interest. What that does is if a creditor gets a judgment against the settlor, they then have to go against the trustee of the trust in order to enforce the judgment and collect on the debt. As a result of going against the trustee, they may even have to go outside the state because the trustee of the asset protection trust, if it's in a non-asset protection trust state, may not have any nexus for jurisdiction purposes in the state of the settlor. We use independent trustees that do not have any nexus in California for our asset protection trust. And we want them to be purely either in Nevada or Delaware or Alaska, wherever we set it up. And we use Nevada a lot for our trust, but it's important that you think about that instance. And I'm going to talk about that more when we get into the area of putting property into the trust.
But doesn't, by virtue of accepting trust assets from other states, give the nexus?
That's an argument, certainly. But it still has to be litigated, and it would be, again, it gives you more leverage. And there are several cases that say that an out-of-state trustee that's independent trustee doesn't have the courts can't get personal jurisdiction over that trustee. They have to be able to get personal jurisdiction over the trustee. They can get in rem.
But that's my point, is if they're managing the assets as a trustee of a settlor outside their jurisdiction, isn't that the long arm that's going to reach out?
It may be or it may not be, but there are some cases that say it isn't enough. And they still would have to litigate it, plus they still have to be able to serve the out-of-state trustee. And then there's an issue like if it's California, there would be a California court motion to dismiss the service, to quash the summons on the basis of lack of jurisdiction. That's going to take time and effort. No matter which way it goes, it still gives you more leverage. And the assets in the meantime may have been transferred out of state. And that's why we always have our clients open up bank accounts in a bank that is outside the state where they are located, that has it's not a federal bank, but a state bank only. And that's important to have the state bank that has no nexus into. Carol?
Well, I'm just thinking about Steve's comment, and if you do the LLC in a state that says it's converted into personalty, then would you be converting a California asset if it still would be a California resident that would hold that personalty? But I'm thinking just with like real estate. Has that real estate been converted to personal property?
That's another issue that has to be litigated. If you put it in, and so if you put it in an out-of-state LLC, and even though it's California property, you can argue that it's now in the LLC, and that's personal property, the member interest. So that's another issue for jurisdiction. Wait a minute, just one person at a time. You're next. Go ahead.
I would say only if a liability arose from the real estate itself. Not technically inside liability, which you have to worry, but not if you have automobile accident.
Right, and it's California resident.
And the fact of the matter is that the court, if they would have in rem jurisdiction over the real estate itself. So you would have to argue that they don't have jurisdiction because it's in an LLC out of state, and that the LLC out of state is owned by a trust, the trustee of which is out of state. So you have an argument, and There are cases that indicate that they won't, just by the mere managing of assets is not enough to give nexus to the domiciliary state. So you have a strong argument there. You may lose it, but again, it's a barrier that the creditor has to overcome. Yes?
Now, it's my understanding there are no cases out there, but there is a case in California that's pending right now in the probate court. Are you familiar with that one?
No.
It's a
Well, I don't know which
rather
one you're
large
talking.
case.
I don't know which one you're
Nevada
talking about.
Trustee, he doesn't have any nexus outside of the state of Nevada, but I think it might even be down in your area. I wondered if you've heard about it.
No. Why don't we hear about cases about domestic asset protection trusts? Why aren't there any reported cases? Everything settles. Everything settles.
So the more arguments you have, the stronger the settlement.
Exactly. The more arguments you can come up with, and the more there are no reported cases on holding the validity of an out-of-state asset protection, even in state. There's hardly any cases. For example, there are hardly any Delaware cases with respect to enforcing the Delaware asset protection law, because everything settles. And the reason everything settles, the asset protection trusts have been around for over 20 years now, 22 years since the Delaware first enacted in 1997. There's been no reported case.